Welcome to Lawyer Up with HMC, where we unravel the complexities of legal battles, share insights into high-stakes litigation, and provide strategies for navigating the legal landscape. Join us as we delve into and discuss common legal issues and interview industry professionals and experts in the field. Whether you're a legal professional, a business owner, or simply curious about the world of litigation, our podcast offers valuable knowledge and practical advice to empower you in your legal journey. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, hmclawyers.com. Now here's the host of the Lawyer Up with HMC podcast, Kristen Hagg.
Lawyer Up with HMC. I'm your host, Kristen Hagg. Joining me on today's final podcast of our inaugural season is Dave Corrigan. This is his second time on the show. He's once again gracing us with his presence to share his immense knowledge on various litigation topics. So thank you for joining us, Dave.
Sure. Thank you. For that, I know you don't mean it, but yeah, sure. Great.
Well, and as always, I should say this is not a live show. So also not everyone that tunes in would do so with video. And I want to paint the picture of Dave and I both wearing our Oilers jerseys. When we started this podcast last year, actually, the Oilers were on their 2024 Stanley Cup playoff run, which ended in a sad way. This podcast is being recorded on the morning of Game 2 of the Stanley Cup Finals against Florida. And hopefully by the time this episode airs, the Oilers are Stanley Cup champions. And if not, we may need to add like the sad face filter to both of our faces for the episode or something. And I know this is not a hockey podcast, but what do you think, Dave? Are the Oilers going to take a 2-0 lead tonight?
I have fairly good confidence that they're going to win this series. I'm not really confident about tonight. So
okay. Yeah, no, and we all know as Oilers fans, we've been through a lot of ups and downs, and we're never overly certain of anything. We are always optimistic in the back of our minds, but we have to protect our hearts. Okay, well, I appreciate that answer. All right, so on to the reason we're actually here, which is to discuss the introduction of no-fault automobile insurance regime in Alberta. And just before turning things over mostly to Dave for his, as I noted, immense knowledge in all topics, I just want to kind of give a little bit of background. So it was March 24th, 2025, the government unveiled Bill 47, the Automobile Insurance Act 2025. And so this is the first step towards implementing Alberta's no-fault model, or what they're calling the Care First model. So it will apply to any accident that occurs on or after January 1st, 2027. So we've got about a year and a half before this is expected to take effect. And so in the act, it's providing effectively that notwithstanding anything else, a person will have no right of action and must not commence or maintain proceedings respecting bodily injury or death sustained in an accident, and that an insurer in respect of a motor vehicle policy is going to have to pay compensation under the act. And now there are going to be some exceptions we'll get into talking about later, but the general thing is that this is a no-fault system, and that's where each party involved in an accident is going to be compensated by their own insurance company, regardless of who is responsible. And under a pure no-fault insurance system, the recovery of medical expenses, lost wages, and other related costs for individuals involved in an accident is going to occur largely without litigation. And so, Dave, where I want to start with you is just sort of generally asking, how did we get here? And we know that there's been a lot of things that have happened over more recent years, but even going back further, what has led us to where we are here today in Alberta?
Well, I think this idea of trying to control litigation costs in Alberta goes back some ways. So I started practicing in 1991, and very shortly after that, there was a case called Duncan and Badley, which allowed the estates of children who were killed in car accidents or in any tortious manner to sue for essentially the loss of a future earnings stream, less expenses. And this went through the Court of Appeal, and the Court of Appeal ended up upholding this decision. And for a period of time, these cases became quite prominent in Alberta, and I think Alberta was was certainly the original jurisdiction to have these cases. But the insurance industry eventually prevailed upon the government to make changes to legislation to sort of do away with that. And then I think in 2003, there were a raft of changes put in, again, designed to limit the availability of certain benefit streams and recoveries in auto cases. And this included changes to the Insurance Act regulations for things such as allowing deductions for private disability benefits, for example. Prior to that, people were allowed to, quote, double recover if they'd pay for the benefits themselves. The insurance industry prevailed upon the government to not allow that kind of double dipping. So this legislation came in. It also made income claims, they were to be calculated on a net income basis as opposed to a gross income basis. So a series of reforms designed to limit these kinds of recoveries. And of course, then the minor injury regulation came in, which was designed to essentially do away with litigation for minor injuries, so that you just get a set amount, and presumably that would be that. The problem with that is, first, there's a court decision that sort of poo-pooed the minor injury regulation. The Court of Appeal eventually reinstated it, but it became clear that all you had to do was expert up to get around the minor injury regulation. And so lawyers began spending more and more time and energy on obtaining expert reports to establish that there was something about the particular case that would take it outside the minor injury regulation. And I think just about more than anything, this led to sort of a real proliferation in expert reports. So something that was designed to limit litigation costs and simplify the system in some ways may have had the opposite impact, because lawyers were, taking steps to get around that minor injury regulation. And, it's easy to say, well, so it's a damn lawyer's fault. And I guess from, 40,000 feet, you could look at it that way, but you have to remember that a lawyer's actual obligation is to the individual client. And so if they are doing something that is designed to help the individual client in that particular case, they should not be faulted for doing that. You could say that the system rewards behavior that is not necessarily good for society, but it's not the, quote, lawyer's fault. The end result, though, is the same. Litigation costs really skyrocketed. And so over the next while, there are a number of proposals and efforts made to try and limit these costs so that the dollars spent on this system are not lost to systemic costs as opposed to going to people who might need them for care or whatever. And just let's do a quick example to show in some ways how inefficient this system might be. So say you've got a personal injury case, which we would call minor chronic pain case, and it would be assessed at $150,000 in damages between wage loss and general damages and housekeeping or whatever. This is not an unusual scenario. Every office that's involved in this kind of litigation is full of these, has drawers full of these kinds of files. So you say, okay, $150,000. What does it cost to resolve that claim? Well, you've got, and I don't even know what the insurance company's, internal overhead would be, the employees for the system, but they're always going to have that kind of overhead regardless as to what kind of system. But in order to get that $150,000, avoid the cap, create your arguments, the way that this system's developed now is you pretty much have to expert up and then go to a mediation. So let's say the plaintiff spends $50,000 on expert reports to do this. Not an unusual amount. Might seem shocking to people not in the business, but that's not an unusual amount to get your psychologist report, your physiatrist report, your cost of care from an occupational therapist, and maybe some kind of an accounting report or from an economist or an accountant. So in that scenario, 50 grand is spent. The defense then would spend, let's say, 25 grand on their response reports. So you're talking $75,000 on external experts, and that's not even talking about legal costs. Let's say the insurer's defense counsel, through a standard case like this, maybe that costs them $20,000. I don't know. So now you've got 50,000 in plaintiff reports, 25,000 in defense reports, 20,000 in legal fees for the defendant, and then another 10 grand between transcripts and miscellaneous expenses and a mediator's fee. So you're up to roughly $255,000 in this scenario for a case that was assessed at $150,000. Well, how much does the person actually get with the $150,000 injury? Well, they'd probably get 100 grand of that after their own contingency fees and GST. So now you're saying, okay, to put 100 grand in someone's pocket, it's going to cost $255,000. 75 of which is or roughly 75 or 70,000 of which is going to lawyers, and then another 75 or so that's going to external experts to the system. So, frankly, that's just not a very efficient model economically for delivering benefits to someone. And so the challenge is going to be, is there a better way to do it, a more cost-effective way to do it? And, for Alberta's sort of the last jurisdiction in Canada standing, I think, that's currently, pure tort. And the other provinces have moved to different systems, hybrid systems, or publicly run insurance programs that are generally done on a no-fault basis. And I think in some ways, the proof is in the pudding, in the sense that the spend for the average consumer for insurance is cheaper in these other places than it is in Alberta, right? Like, at the end of the day, that's a hard thing to argue about. If it costs more, it costs more. It's not as efficient. Is it better? Well, maybe. There are elements of our system that are better, that appeal to certainly the way that Albertans think, fault-based, all of those kinds of things, right? Like, so for sure, there are sort of theoretical reasons to favor a tort-based system, but from a practical standpoint, it's become inefficient in Alberta in our model. And as has been shown repeatedly, I'm not a big reader on this or anything, but I do sort of pay attention to events in my own lifetime. The capitalist system is merciless in terms of eliminating inefficiencies. Lawyers might not like it, but the lawyers in this industry and law firms in this industry are going to be impacted in a way similar to sort of how other industries have been impacted previously, whether it's through offshoring or mechanization of assembly lines or whatever. It's just capitalism, and it's tough. It's tough for the sort of people that are in the middle of it, but that's kind of the way it is. What's interesting about what Alberta's talking about doing is they are talking about running a no-fault system, or they've decided to run they've decided to run a no-fault system using private industry, private insurance companies. And the justification for this is interesting. They're saying, well, you'll have way more choice, way more options. It'll be a marketplace that will, the best will survive, and all of this is true. And so in some ways, it's really an interesting experiment to see whether private insurance companies can operate this better than a public system. And the challenge, sort of the fundamental challenge that I see on this is insurance companies are like any other, corporate entity. Their highest obligation, at least in the last 15 or 20 years, is to shareholder value. And so the motivation of the company is to maximize its efficiencies and its profitability. So does it really, are you set up for success when an insurance company is, through the first couple layers of these assessments for these no-fault benefits, the insurance company is policing itself in a way to determine what benefits should be paid and how they're going to be paid and whether your appeal should be successful. And eventually there's some third-party accountability, but it takes a long time to get there, and it's going to be hard for people to get there. And private industry is not known for necessarily providing sympathetic results to people, or empathetic results. It's more known for maximizing profitability, which is its stated goal.
Well, and we already kind of see that a little bit in WCB, and that there is already the no fault medical benefits. There are going to be issues with it. There's going to be issues with every system, and we'll get a little bit more into what the province, at least at this point, is proposing in terms of what the damages might look like, what the payment durations are going to be, and how those will stand up to compensating people as against the tort system. There's one more thing that you and I have talked about, and we've obviously talked about this a lot over the last 5 years. When you were talking about the inefficiencies in the system, and some of the things have been lawyer created, but in a way it's not. Lawyers are doing their job, and they're doing the best they can for their clients. We also talked a little bit about just, the way the insurance systems work in the US versus Canada, and also just how maybe the courts have also kind of contributed to there being not now more expensive cases. Obviously with their findings on the minor injury regulation and stuff like that, they didn't help out a whole lot, but mandatory mediation, just making it hard to get trial dates for personal injury claims. In a way, the system now has more cases than it would have had otherwise, right?
Yeah. So yeah, this is a really interesting thing to me. So we say, why has the tort system not been as efficient in Canada as it appears to be in the United States? Because, the United States is not all moving to these kinds of systems, even quote blue states. There's very little talk of this kind of a momentum for this kind of a change, and I think you need to look at a little bit about, at a number of different things that have happened over the years. So for me personally, where I think the tort system went off the rails for insurance companies, there was a change made to the Jury Act this would be late 1990s, I believe. I can't say for sure, but I believe that's the timing, late 1990s, early 2000s. Prior to then, you had a fundamental right to a jury trial, unless the case was shown to be too scientific or too confusing. And the fundamental right applied under the Jury Act to any case over $10,000. So there was a time where defense lawyers, including me, were running these cases, bringing jury applications, and running some jury trials. And in Alberta, the jury trial system was very effective for limiting awards for minor claims. Juries didn't believe people had all these problems from these minor car accidents. That this was borne out repeatedly, and as a result of this, there was a period of time where a lot of these minor cases were being settled for peanuts, and I mean peanuts. Like you'd get the jury order, and what would happen is people would settle. They didn't want to run a trial if they thought that there was going to be a $500 or a $1,500 award. And BC actually had a long history. ICBC was doing this in BC, and their experience was, in many ways similar, at least in that time period. Then, as I understand it, and I don't have personal information on this, I can't remember where I heard this, but I understand that the insurance industry asked to move the cutoff for the right to a jury trial to $75,000. And this made a huge difference. 20 years ago, $75,000 would be the equivalent of, 150 or whatever right now, because all they had to do was drop their claim to $74,500, and you no longer had a right to a jury trial. And there were actually, this is what happened. And so the whole idea of pushing these cases to jury trials kind of ended on these minor stinky claims. And as a result, the cases were not being settled really quickly, and it seemed like it started pissing the courts off that they were being clogged up with all of these cases. So then they started pushing, the alternate dispute resolution and making it mandatory. So you had to do either a JDR or a private mediation. Well, very quickly, the whole ability to secure JDR dates disappeared, and they release a few dates, but it was effectively impossible because the courts essentially decided they were going to download the costs and the responsibility onto private individuals to deal with all of these cases. They wouldn't give you a trial date until you did your mediation, and so the system developed that really no one ever did trials anymore, and they just mediated cases. So without the fear of trial, without having to worry about, doing really poorly in court. These cases no longer held a sort of a fear element for people pushing them, and they were able to push them to mediations repeatedly, and it developed into that's not what happens. So now, the vast majority of these cases, once it goes to a defense lawyer, they end up in mediation. No one settles before then. No one calls each other and talks and resolves cases. It always settles at the mediation. Well, people have learned, lawyers and insurers, that if they go to a mediation and they don't have their case in order, then the mediator is going to be hard on them, and they might have to pay too much or get too little or whatever. And so all of that just changed. And that also encouraged sort of this proliferation of expert reports and so on. So now every case goes to mediation, and no one settles beforehand, and every case gets 2, 3, 4 reports. And so all of those ancillary expenses that used to be the exception are now the rule. And the system, the costs associated with the system have just blown up. Now, how could that have been avoided? Well, if insurers had continued pushing cases to trial, that would have had a major impact, because if the good citizens didn't think this particular case is worth $150,000 and instead gave $5,000, well, and a law firm gets stuck with $50,000 in disbursements that they have to eat, they'd be less likely to do that the next time. And in the U.S., they litigate far more cases. They don't have a system designed to encourage settlement at a certain stage after all of those costs have been incurred. And so if they litigate far more cases, people have to understand that they can settle early, maybe cheaply, or they can push the case, and there's a very good, a very real chance they'll go to trial with all the ancillary anxieties and risks. And the other thing about the U.S. system is the mandatory insurance limits can be quite low. So that also, if an insurer has a relatively serious accident and their insured only has $25,000 on their policy, they just pay it and close their file. And the insured is, maybe they chase them, maybe they don't. And so people are, at the end of the day, responsible to protect themselves through their own insurance. Similar to our SCF 44 policies, they could pay for as much or as little as they want. And some pay for lots and some pay for not much. But it's almost self-limiting. And the way that they've got their system set up, it does not encourage every Tom, Dick, and Harry to go crazy on their disbursements. So different system, different result. But here we are. This is the system we've got, and it's no longer efficient. So it's going to change, and that's just the way it is.
Now, I've before we go into actually talking about the new system, I have heard a lot of people, and maybe this is just wishful thinking for those of us that are kind of in the industry, saying, "Oh, I still think this might not actually happen," and stuff like that. Like, do you think there's actually any, this is happening, right?
Yes, Kristen. As you know, I have been hectoring people on this for many years. As I understand it, this was going to happen in 2020. There had been some kind of a commission that had gone and talked to a bunch of people, and they had a report already, and then COVID happened, and it just kind of got pushed to the wayside. But I understood that there was huge momentum for this way back then, and it just got waylaid by the vagaries of a worldwide pandemic. So this is going to happen. If you look at the numbers, the math we just did, this is not efficient. And so we can talk about, how other systems are lousy or whatever. And there's an element of truth to that. But where we are at right now, it just can't go on. It costs too much to provide too little. And so, and certain industries, the people that write the reports and the lawyers and all of these things, they're just taking too much money out of the system to make it efficient. So, and this is a tough thing for lawyers to look at and think about, because this does impact real people, right? And it's a real challenging thing to think that things are going to change this much, and what about all the people that work in these offices and so on, and there'll be real job losses. But that's kind of the way of the world. I know that for a long time, residential real estate was a very lucrative field for lawyers to be in the 60s and 70s. And from what I understand, in Alberta, it was kind of the most lucrative field to be in the 60s. And it changed. Eventually, people realized that they didn't need to, spend 10% of the cost of buying a house on their lawyer and all of that stuff. So it changed. It was no longer lucrative. People undercut it, and it was no longer something that lawyers made a bunch of money off of. And this really is no different. Funny story. What I understand is one of the original big time personal injury lawyers was someone who morphed from having a big real estate practice to having a big a personal injury practice, with many of the same sort of techniques in terms of advertising and setting up systems in their office and all these kinds of things. So it's just the way of the world, and it just happens to be that and Kristen, this is in our office. This is affecting our office, and so this is not a quote happy thing for our office necessarily. But I look at this and say, when you sort of sit down and you look at where the system is right now, the system right now is not an efficient system, and so we have to recognize that in some ways society deserves better, even if it's kicking the hell out of our office and other law firms. And even though, and I guess that doesn't mean that what the government's planning to do is perfect by any stretch of the imagination. But you can't just keep putting little band-aids on things if you have to make fundamental changes at some point in time.
Right. And they tried to do incremental changes, and it didn't get better. In fact, got worse. So, and I mean, lawyers are going to be affected. We've been talking about this for years, but what's also matters is how, individual, formerly litigants or people that have been injured are going to be affected. And kind of looking at what they're proposing, at least at this point. Like, this is obviously going to have to be fleshed out quite a bit more, but they've referred to a common injury, which sounds just the same as the minor injury. So you'll get some maximum compensation amount, and then your out-of-pocket expenses, and hopefully be recovered and move along with your way. There's this kind of middle of the road, which would probably be the bulk of cases that end up being litigated right now, the serious injury, where there is a possibility of a lump sum payment between $1,000 and $187,000, in addition to the different, treatment costs and out-of-pocket expenses and things like that. And then finally, the catastrophic injury one, where the lump sum would now go up to $295,000. So, bearing in mind, obviously, I think it's kind of obvious on the catastrophic one, there can be some shortfall, but just in terms of if people are no longer, have a third of their uh, the money they get go to a lawyer or whatever else, like, do you think what do you project? Do you think this system is going to result in problems or people being undercompensated?
I think this system is going to take 10 or 15 years to work its way into an effective mechanism. And there's going to be lots of problems and pain and headaches for a whole bunch of different reasons. But if you what's the closest parallel? Maybe the Workers' Compensation Act, right? The Workers' Compensation Board is not a beloved entity in Alberta or most jurisdictions. People are fighting with the WCB all the time about this and that. So there will be friction, there will be difficulties, but at the same time, for people who are in really rough shape, people who have significant problems with mobility or paralysis, significant brain injuries, the systems often work fairly well for those people in terms of ensuring that they get funneled into appropriate treatment regimes and appropriate retraining and all of these kinds of things. Where the system really struggles, and in some ways the legal system, the current legal system as well, is dealing with the cases that aren't so clear cut, right? The cases with the psychological overlay, the cases with people who have had a whole bunch of different things that have impacted them in a negative way over many, many years. And how do you parse out what's what? So unfortunately, it's going to take time. It's not going to be smooth. But from a theory standpoint, this should be better, right? It should be better. In the sense that, even people like if you have someone who makes an inadvertent mistake and is now paralyzed from a car accident, under the current system, that person has access to some minor Section B benefits and for 2 years of income loss. And then they have the right to a certain cost of care benefits under their no-fault insurance Section B benefits. But in terms of larger compensation, and unless they qualify for AISH or something like that, at the end of the day, they will be severely undercompensated for their momentary inadvertence. And there's that person will now receive the same level of compassion and so forth as someone who bears no measure of responsibility for their injuries.
No, I think that's actually that is a very good point. I mean, obviously, the average Albertan, what their primary concern is really is just, what do my insurance premiums cost? But I think beyond that, if they know that their insurance premiums are going to help them in either scenario, that's probably a good thing. I mean, it's good to look at both sides of this. So kind of moving on, I mean, there are some exceptions to situations where there are going to be opportunities for people to still bring claims. So one of those is where an at-fault driver is convicted of a prescribed Criminal Code of Canada or Traffic Safety Act or other legislative provisions. And then they'd be able to sue for their general damages for pain and suffering, less any other benefits paid. And then there's some other.
So can I make a comment about that?
Yeah.
I think this is a lunatic provision, because you can see how something like this would come up. You'd be sitting in a caucus meeting, and some backbencher from somewhere would chime up, well, what about the people who were driving drunk or were texting while driving? They should be punished. Yeah, they should be punished. So, okay. So let's look at this practically. Someone has an accident, whether they were impaired or whether it was a reckless left-hand turn or whatever. I don't know how they're going to write this up in terms of what's covered and what's not, but it's going to require a conviction. So now, if someone wants to plea bargain that down, are they going to have criminal negligence causing bodily injury is covered, but dangerous driving is not, for example? Or are they going to have careless driving, the 7 demerit ticket is covered, but not the 4 demerit speeding ticket? So, insurance companies would be motivated to assist their negligent insureds in beating these charges in some ways. And people will be howling at prosecutors who might make deals if the result is they can't sue anymore. So there's all these ancillary sort of problems with this, and again, who knows what this is going to look like? But presumably, you're entitled to sue for it's general damages and punitive damages. Is that right? Yeah.
Yeah, I believe so. Yeah.
So it's gonna be a weird thing, and there's many potential problems with this. And I don't know. Obviously, some lawyers are gonna take those cases on, but it's going to be an interesting little thing to see how that works out as well. So seems problematic to me. Too many sort of ancillary problems with that.
Yeah, I think you're right. I think somebody, they're having this discussion and they're like, we should probably have, these offenses and certain traffic, maybe some of the traffic safety act stuff. They're like, well, which ones? That's tomorrow's problem. Let's not worry about that right now. So I think they are going to have some difficulties and troubles with that. And as you said, yeah, it's probably just going to lead to, the system adjusting and causing other problems. And then the other exceptions, there might be certain discrete parties such as automobile manufacturers, garages, liquor vendors, social hosts, municipalities, for their several liability. And then you could also sue for earnings or medical expenses in excess of the compensation you were provided. This is also going to be, very few cases, right?
Oh, I think in some ways, if it was joint and several liability, it might be lots of cases, because we do have lots of commercial host cases, and our offices run cases involving municipal liability and all these kinds of things. So these things happen. They're not that unusual. But now that you're talking about several liability only, there won't be many lawyers who want to take those cases on, because let's say you do have someone overserved. The case law says that might be a 25% responsibility, as opposed to the person who was overserved and chose to drive. So, are you going to go through all of that for a chance at a 25% recovery under the old system? And I fair enough, they can carve it out, but by making it several as opposed to joint, it's a fairly hollow thing, and I don't think it will do anything to dissuade the behavior that you would typically look at a tort system to dissuade. Tort systems have had an impact on commercial hosts by encouraging them to be careful with how they serve people, because of joint and several liability over the years, where catastrophic cases. I had one myself many years ago where the driver only had $1 million in coverage, and it was a $4 million claim. So the commercial host very well might have only had 25% responsibility for over-serving. Didn't matter. They were jointly liable, and they had to pay much, much, much more than that. So by taking away that, you may inadvertently take away the motivation of some of whether, I don't think it will really impact municipalities much, but certainly commercial hosts, that would be something that the power of joint and several liability did impact commercial host behavior.
Since you mentioned commercial hosts, I'm obligated, because of the family I come from, to mention a great Supreme Court of Canada case called Stewart versus Petty. So if you have time to read that one, that's a good one. The great Daniel W. Hagg, KC.
They're still teaching it. They're still teaching it in law school today. So I was a young lawyer when that case was working its way through the Court of Appeal, and then the Supreme Court with your dad running that case. And it is still taught today, I believe, for the principle of foreseeability, actually. So it was on my son's syllabus, his tort syllabus. And actually, two of your dad's cases were on this tort syllabus, the resurface one as well. So,
well, I'm glad to hear that resurface is still on there, because Clements had sort of taken over on the causation side of things. But yeah, you still got to work through the whole history and how Hankey and resurface completely derailed things for several years there, and then they tried to get it back on the rails. But anyways, we digress.
We did digress.
I have to bring up my dad's great Supreme Court triumphs, because I certainly don't have any. Anyways, I guess I think we've kind of fleshed this out as much as we can in 45 minutes. Like I said, we've been talking about various aspects of this for 5 years. Do you have any closing thoughts or other things you wanted to get into?
Well, I guess as much as anything, I think there will be pain. There will be chaos with it, transferring from one system to another. I personally wish it wasn't so, but that doesn't mean I personally wish the system would continue as it is, because I think the system right now is terrible in terms of how people are, how lawyers are incentivized to push the cases forward. It's counterproductive, but it is what it is. So there's going to be a transition period that will be painful for people going through the system as insurers get things set up, and then there will have to be some examples of insurers who behave poorly being held accountable, and then 10, 15 years from now, the system might be fully functional and might be in many ways a lot better. Obviously, for law firms who are directly impacted by this will be a bit of a painful thing. But lawyers have lots of skills, and they should be able to adapt, and there will be a transition period that will be painful. But that is not really any kind of a reasonable consideration when you're analyzing whether the system is proposed system is good for society or not. We have to adapt. So there you go.
Yeah, and I was on mute, but I knocked on wood when you said hopefully in 10 years the system is running smoothly. And yeah, I've tried to have some perspective on this. Lawyers, we do have skills and we can pivot, particularly when we live in a province like Alberta with what we've seen with certain positions in the oil and gas industry effectively becoming obsolete. You try to be grateful about, there's an opportunity ahead to just go in a different direction, and yeah, we'll make the most of it. So
what's the next big thing, right? For lawyers,
Mm-hmm.
Maybe you should do a podcast on that. Looking
well,
ahead.
Ironically, my brother because my brother's a lawyer as well. He said, you should do real estate. So it's kind of funny since you said, We'll see. We'll see. He's like, I can teach you everything. Anyways, we'll see what's going to happen. But yeah, just as we are with the Oilers, I'm going to be as optimistic as possible. And so, yeah, I think we can wrap this one up. I won't say catch you on the next episode as I usually do, because we don't know for sure if we're doing another season. So I'll just wrap this one up by saying thanks again, Dave, for being here, and go Oilers.
Go Oilers, go. Yes, just like the chant in the building. Go Oilers, go. Thanks,
You've been tuning into the Lawyer Up with HMC podcast with your host, Kristen Hagg. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, hmclawyers.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.